Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann. Shona Sanford is out this week. Thank you for joining us. Today we address a topic that has been stirring quite a bit of controversy lately, especially since the recent Zimmerman verdict. From the news media to the President of the United States, everyone is discussing the law known as Stand Your Ground. Do these laws help or hurt in terms of individual rights and safety inside or outside of one's home? In the last 8 years, many states have either adopted Stand Your Ground laws or similar mandates. We'll explore these trends and more in a two-part series on an individual's rights to defend oneself inside or outside the home versus the rights of individuals suspected or of posing such threats. To help us in the discussion, we're honored to have with us today retired Orleans Criminal Court Judge Calvin Johnson, who will talk to us about the Stand Your Ground laws. We'll get to that discussion and your questions right after this short break. Stay with us.
This new phone is awesome. It has made my life so much easier. You know, I get kind of bored when I'm driving and I need to know what's going on. So now, with this huge screen, a keyboard, and a ton of apps, I can get a text and write back right away, no problem. It's like I barely even have to look at it.
Hello everyone and welcome back to the show. Today we're talking about standing your ground, defending yourself in situations where you perceive you may be in danger. What are your rights in these situations and how does the law work in these scenarios? I am joined by the Honorable Judge Calvin Johnson. Judge Johnson received his Juris Doctorate from Loyola Law School in 1978. He was elected to the Orleans Parish Criminal Court in 1990 and then as Chief Judge in 2004. He was the first African American judge and Chief Judge of that court. Judge Johnson retired from the Criminal Court in 2008, at which time he was appointed Interim Director of the Metropolitan Human Services District by the Governor. Today he serves as the Executive Director of that organization. Judge, thank you so much for being with us today. We're delighted to have you.
Thank you for having me. Thank you.
We've got a very meaty topic to talk about, something that you witnessed as a judge in Orleans Criminal Court on plenty of occasions, I'm sure. That is where someone was accused of shooting or injuring somebody who was entering their home or who accosted them on the street. And then you had those people, victims of this, who said that they were just in the wrong place at the wrong time. So why don't we start with you giving our viewers just a general idea of what are Stand Your Ground laws?
Interesting. It comes in our law under Revised Statute 14, Louisiana Revised Statute 14:20, which defines justifiable homicide in Louisiana. And the law has a lot of nuances within it, but it's based on the premise that an individual can be justified in doing the ultimate act of killing or taking another's life under certain circumstances. And so then the law defines those circumstances. It has changed over the course of time. So now we see, and even in Louisiana, something akin to stand your ground. Historically, the law was that you had to believe, not only believe, but that belief had to be reasonable based on fact and circumstance, that your life was in fact in danger, and the individual killed could in fact do great bodily harm to you, or at the very least kill you. And so, based on that, you could be justified in taking that person's life. Right. But that all said again, it had to be reasonable.
Okay. And it's a very hot topic these days. It's all over the news because of the recent Trayvon Martin case, where Mr. Zimmerman actually was acquitted by the jury. And it's been a very debated topic about whether or not Mr. Zimmerman was profiling and whether or not he was in a stand your ground situation. But full disclosure, my understanding is that Mr. Zimmerman did not try to invoke stand your ground laws, but he did try to call it a justifiable homicide, which the jury accepted, and now he has been acquitted of that.
Correct.
So in Louisiana, same sort of laws exist, specifically 14:20, which says you may be justified in committing a homicide or a murder or killing somebody, and you just have to be reasonable. Oftentimes they don't even prosecute people who find themselves having to defend their ground, right?
Oh, that's absolutely correct. And the number of instances when we've had someone who takes a life in Louisiana based on a belief that their life was in danger, the number of cases are legion where you see that thing take place. In most instances, though, at the bottom of it is a belief from law enforcement or from a district attorney or from a grand jury or all three that the action taken by the individual who pulled the trigger was in fact reasonable based on the attendant circumstances.
Right, and just to help sort of flesh that definition out a little further, you can stand your ground if it's inside your own home, and you can stand your ground if it's somewhere out in public where you are being accosted, you're being attacked, when you could be at the shopping mall, you could be out in the street, and someone you believe puts your life in great danger or puts you at risk of great bodily harm. The same law may apply to allow for what's called a justifiable homicide.
Absolutely, and it's easier to understand actually if you're inside your home, because we've grown up with the notion and belief that our house, our home is our castle, and we can protect our castle. We can protect ourselves inside of it, we can protect our loved ones inside of it, but we can also protect our property inside of it.
And
so that's a belief
I
we
want to
have.
get into that, but is that commonly called the castle doctrine in Louisiana?
Doctrine.
You can
That's the
defend your
castle
castle. So if you believe someone is out to do you serious bodily harm or even do great harm to your property, that you may be able to commit a homicide and be justified.
That's always, in some form or fashion, been the law in Louisiana, because that's always been the law in English law. If you go back historically, that's always been a part of our law. That if you are in your home and someone comes in uninvited, someone comes in unlawfully without having a right to be inside of your home, and they come in, one can assume if they've come in unlawfully that they've come in to do me bodily harm, and therefore I can do something to them before they do something to me.
And when you say one can assume, the law says you have to be reasonable. In other words, if someone has walked in and they have fallen asleep in your front doorway and they're asleep and you come across them, that assumption goes out the window. You can retreat, you can call 911, but you don't have to retreat if they're actually coming at you. You don't have to run away.
Absolutely not. That individual who comes in again, and he comes in by means not through your door. I mean, they come in through your window.
Right.
Well, you can assume if someone comes in through your window and you're inside of your home, they've come in to do you bad things.
Right.
And so you can do a bad thing to them first. That's just generally the notion of law.
Okay, and there's a downside to this. Sometimes people in the wrong place at the wrong time get injured, and the stand your ground law might still get the person who shot the intruder or killed the intruder off the hook, but the risk is that innocent people who, for reasons we can go into, are in that home and not expected to be coming into that home, and they're killed.
That happens, John. That's happened so many times in our community, where the innocent person has been killed by their friend, who the friend thought their home was being invaded, and in fact the person coming in is a friend who had a right to be there.
Give me an example, just for our viewers.
A classic one was at Tulane, where a student left, roommate, sleep, went to campus, forgot something in their apartment, came back to the apartment, forgot their key, came in through a window. The person who woke up and killed the roommate. That happens, and that happens with frequency in Louisiana.
And in that instance, the person may be coming in through the window, it's dark. The person who's, let's say the roommate in that example, is afraid for her or his life. They see a dark silhouette coming in through the window. Without asking questions, they shoot first.
They shoot first, ask questions later, and it's too late to ask
and
questions.
under the law, this person, if the jury decides they acted reasonably, that person who shot first is justified in the homicide.
In most instances, you never get to a jury, because those instances or those kinds of events are never prosecuted. There's no prosecution that happens in cases like that. But what you see, though, over the course of time is the person who actually pulled the trigger and the torment that they go through in their own lives as a result of the act taken.
Yeah, that's a heck of a cross to bear, isn't it?
It absolutely is.
Well, there's been a lot of stuff in the news lately about gun laws in Louisiana being strengthened. A constitutional amendment was passed that made it basically even more of a constitutional right than it already was to bear arms. In association with that, in recent years, the Stand Your Ground laws, or what we'll call the Stand Your Ground law in Louisiana, has been modified and strengthened on behalf of the person in the home or the person who believes he's being accosted. What was that amendment?
That dealt with, again, the notion now that in Louisiana we're going to raise the right of an individual to carry a gun. We're going to raise it to the same constitutional standard as we have in terms of Second Amendment law. That it is now a constitutional right, and to abridge that right, one must look, the government or state must operate from a premise that the judges are going to look strictly at how that law was passed and what that law does to determine, in fact, whether you have curtailed in any way the right of an individual in Louisiana to possess or carry a gun.
And there's a corollary to the strengthening of the law, if I'm remembering my research. That is, a person who shoots an intruder, and it turns out to be a mistake or not, is immune from liability in the civil courts. You can't be sued for a wrongful death claim on behalf of the, let's say, the family member of that roommate.
That's absolutely correct. That's now part of our law. That if in fact if in fact the law justified the act taken, you cannot be sued civilly for it. In Florida, you can't be investigated in some fashion in Florida. Louisiana still allows police or DA, et cetera, or grand jury to form a coroner to perform some kind of investigation as to the act.
To determine if it was reasonable,
to
right?
determine reasonableness,
Okay.
but you can't be sued civilly.
Okay. And so, you know, in Louisiana, we've had similar instances like we saw in the Zimmerman case, where somebody was in the wrong place in the wrong time, and it's not entering somebody else's home. There's the very real possibility that someone's going to be killed accidentally because they were perceived as an attacker, and the shooter or the killer is acquitted or is never even prosecuted, correct?
That's correct.
Okay. An example of that is you're walking in public, somebody perceives you to be pose a serious bodily threat to themselves, and in response they take the innocent person's life, correct?
That seemingly is the law. Now, how it will play out in real time with real events remains to be seen, because when the law simply says that all I have to do is perceive a threat to take the ultimate act, that in and of itself will cause great stress in our law.
Right.
When all you have to do is have a perception that something bad is about to happen.
Still got to be reasonable, but you've got a lot of leeway.
There's a lot of leeway there, John,
in the courts.
and without having some either by legislative definition, some definitions of this, or by case law in terms of our courts bringing some definition, by way of example, what we're actually talking about. Until those things happen, we're going to see consistently how the law is ill-defined and ill-perceived.
Well, we're going to continue the discussion, but right now we need to take a short break. Coming up next, we will take your questions, so stay tuned, and we will be right back.
We can beat this. The spill in the Gulf, it's a catastrophe.
But we will solve it.
This is not a Gulf Coast issue.
This is a national problem that requires a national solution.
But what can you do to help?
What do you have to offer? Your voice.
Speak up.
Add your name to the petition
Demanding restoration and protection
Of America's Gulf Coast.
Sign it.
Share it.
Be the one.
Be the one. RestoreTheGulf.com.
Welcome back. Every week on the show, we like to get our viewers involved in the conversation. This week, we're talking about stand your ground law, and viewers have several questions they provided. We'll get to these questions, and I want to make sure we continue the discussion along the very same lines. So, one of the first questions is, what if I am babysitting or house sitting, and I need to defend myself against an intruder or worse, even the homeowner? Can you comment on that?
See, that's where it gets murky. But if I am in this house lawfully, as a babysitter, I am in the house lawfully, and I believe that the house is being invaded, I have the same right as the owner of that house to defend myself or to defend the property. I have the same right. Right. There are dangers in this, though, obviously so, but I have the same right.
Again, you can't just shoot because there's a knock at the door and shoot right through the door because you're scared. It's got to be reasonable.
And here again we get to that big old word reasonable and reasonableness, and what does it mean? And it's defined based on circumstance and situation, invariably how it's defined.
And so even in that question just asked, what if it's the homeowner coming home early from the trip?
Here again, that accident. See, then the accident happens because the babysitter or the house sitter believes the homeowner is coming home the next day or the day after, and reasonably believes that the home is being invaded. And that babysitter, that house sitter would have the right or would be justified based on the act justified in doing it as long as all of the attendant circumstances, again, point to reasonableness.
Let me ask a follow-up. Well, here's another question from Brandon. Do these laws apply if you are staying at a hotel or renting a home?
That's, again, good question. If I have rented this room, then this room is my castle. But there are obviously some other things that come into play if you're in a hotel because of the way hotels operate. That is, people like maids, etc., come in. And if you don't want the maid in, then you put something on your door saying, do not disturb.
I think, and let's hope the maid's going to knock first before entering.
Absolutely, absolutely. So you would assume that behavior on the part of the hotel employee is going to be based on again, what that policy of that hotel actually is. So if you're in a hotel room and you do something, that person coming through that door would have to come through that door in a fashion that would give that person inside that room a reasonable belief that their life is in danger. Not that the maid just opened the door. Right. Because that arguably would be unreasonable.
Okay. Well, you've made it clear that as long as you're in your castle, whether you've rented the place or you live there, you own it, or you're on vacation in a hotel room, what if you see an intruder breaking into your neighbor's property? Do you have the right to go over there and confront the intruder?
You know, there is in Louisiana law the concept that you not only can you defend your home, but you can also defend your property. You can also defend your automobile. You can also defend it. Whether that extends to a neighbor's,
somebody else's property,
somebody
or
else's
home
property,
or someone else.
My knee-jerk answer to that is no. However, again, it may, based on, again, attendant circumstances, based on how reasonable that act actually is when you look at all the facts that surrounding it, it may in fact be reasonable.
And is that because, big picture-wise, if you have the option of retreating without taking a chance that you might be killing somebody who's innocent, you should retreat because that's the more reasonable approach?
It's absolutely, and you ought to call the authorities in. You ought to call those people in whose job it is to enforce the law, and you ought to give them that opportunity to do so. And you shouldn't we should never take law into our own hands. We ought to leave it to people who are supposed to enforce and who are.
Yeah, unless it's the last resort. In other words, if you're backed into a corner and you can't wait for the police to come, then if you're acting reasonably, then you have no worries defending yourself.
Absolutely, but of course, the new law says you don't have to be backed into a corner.
Right.
You don't have to be up against a wall. You don't have to be, the thing doesn't necessarily have to progress to a point where I'm going to get a knife in my throat unless I kill. It can be something, John, as a belief that that person who I am engaged now with in some kind of fashion that's not reasonable, but that person does something that gives me the belief
Yeah.
that my life now might be in danger. That person goes into their pocket, and based on everything that's happened so far, it's reasonable for me to believe in their pocket is a gun. I can shoot that person.
Right, and that's, and I bet you saw that in your own courthouse, where someone accused of committing murder says, no, I thought that he was pulling a gun out of his pocket. Turned out to be a stick of gum or, you know, a cell phone, but I thought he was going for a weapon, and I felt like I didn't have a choice.
We've seen it in terms of police encounters with individuals on the street. We've seen that kind of piece play out. We've seen it in terms of your private citizen. Again, we've seen that piece play out. And invariably, though, it has been a determination by jury or either grand jury or petit jury as regards whether that was a reasonable belief.
Right. And the DA goes to the grand jury or the petit jury to ask the grand jurors, this isn't the actual trial, but in order to make a determination whether to prosecute.
Or not. Absolutely, whether you prosecute or not. Okay. And in so many instances, the decision is not. That's just a fact. The decision is not to prosecute.
Let's turn it around. Here's a question that asks it from the other direction. If I am presumed to be a threat and have done nothing, in my opinion, to provoke a fight, how can the other person try to claim that it's stand your ground defense?
They can always try to claim, but the fact, what all of those facts and circumstances that surround that event or incident will determine ultimately whether or not that was a reasonable belief on the party who did the act, that I had the right to stand my ground.
And reasonable, again, it's one of those things where if you ask a bunch of halfway educated, not even educated, just bright people, they don't have to have a formal education, do you think that what this person who defended himself or herself did was okay or appropriate? And if they all say no, that was a way too big an overreaction, nobody reasonably would think they're in danger in that situation, then you might be prosecuted for murder or manslaughter. On the other hand, if just talking with a bunch of people and they say, well, no, I think that was reasonable, and that's what the grand jury might do too, to help the DA, the district attorney, decide if he wants to prosecute.
You know, this may be a bad way of putting this, but reasonableness almost becomes like that old saying about pornography. I may not be able to tell you what it is, but I know it when I see it.
It's hard to define.
Hard to define.
But you can say, in the word reasonable, most people know what that means. That means you had good reason, or it was not unreasonable in order to proceed that way. Well, let's talk for a minute about what are some of the ought tos. I mean, suppose you're going to be, you're on your own, you live in an apartment, or whether or not you're on your own, what should you do if you believe you hear somebody breaking into the house?
The first thing you should do is call the police. I mean, the first thing you should do is call 911. That's always the first act a citizen should take, is to call the rightful authority to come and deal
hopefully you
with
get
this.
911 and they're on their way. Any other constructive thoughts?
Sure. If you still believe that there is in fact someone and they're out there and they're about to come in your house, you need to start something on your part to protect yourself. Okay. Now, what does protection mean? But you need to do something, some acts on your part to protect yourself.
You know, as long as you're armed at this point. If you have no weapon, then maybe you just want to hide. But if you're armed and you want to stand your ground, would it be good advice to yell out and say,
Absolutely.
Identify yourself?
Absolutely. Absolutely.
Say it good and loud, call it out a couple of times, and then if the person doesn't speak back to you and say, hey, it's me, it's your roommate, it's your spouse coming home early from a trip, that might be one way to avoid a terrible mistake.
I mean, it just almost, you could say, common sense says that after I call the police, or even at the same point I'm calling police, that I ought to make it clear to the person who I believe may be coming in uninvited, that I make it clear to this person, you're not invited.
Right.
You're not invited. This is who I am. I live here. You don't. You're not invited. And do not come any further. Do not come inside of my house, et cetera, et cetera. But you ought to do that before you pull a trigger.
And some people might have a different opinion. My opinion is, if you can safely exit your house and not leave behind a child or anything, any situation like that, get out, if you can get out of that, retreat from that dangerous situation, or what might be a dangerous situation, retreat. Go to your neighbor's house and get them to call the cops.
If retreat is possible, then it'll be a wise thing to do to retreat, because even where you've called out and you've gotten no response, that could be because of something else existing outside that door that you're unaware of.
Right.
That person outside that door may again be a person that, for whatever the reason, can't respond. So the better part of valor would be to retreat if retreat is possible.
Okay, well, it's been a fabulous discussion. We're going to have a second segment, a part 2 discussion of this. But for right now, we're all out of time. We want to thank you, Judge, for being here with us today, and we look forward to continue the discussion with you in our very next episode next week. So join us next week for our next episode, and also catch this episode and any other episodes on our website, johnredmannpoa.com. Don't forget to like us on Facebook, follow us on Twitter, and keep sending in your questions. Thanks for watching, and we will see you next time on John Redmann, Power of Attorney.